Hi, welcome to Constitutional Chats, hosted by me, Jeanine Turner,
and Cathy Gillespie,
with students
Dakari Chapman
and me, Toba Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
Hi, welcome to Constitutional Chats, hosted by Jeanine Turner and me, Cathy Gillespie, where Jeanine and I, along with Constituting America's student ambassadors, Toba Kaplan and Dakari Chapman, chat with experts about hot topic constitutional issues. We'd like to start today by thanking our this week's sponsor, Jane and Greg Gandy of Fairfax County, Virginia. Jane and Greg Gandy are huge Hillsdale fans, Professor Morrisey, and they are so excited to be sponsoring this special constitutional chat today. Our founder and co-president, Jeanine Turner, is not with us today, but I want to talk about Jeanine for a second. Jeanine is famous for her role as Maggie O'Connell in television's Northern Exposure. She is the founder and co-president of Constituting America, which launched in 2010. Jeanine is still acting, but she's also actively teaching kids about the United States Constitution, giving over 620 speeches to classrooms across the country. And Jeanine is just the creative engine. She's the heart and soul of Constituting America, and we're looking forward to having her back with us on Saturday. Now, I want to also introduce Toba Kaplan. Toba is 16 years old and lives in Chicago, Illinois. She currently serves as the National Youth Director for Constituting America and runs the National Youth Advisory Council. Toba is a 3-time winner of the We the Future contest. In the entrepreneurial, where she created a marketing plan, PSA, entitled Know Your Rights, Read the Constitution, and STEM, where she created an app. Toba is passionate about educating and empowering young people to use their constitutional rights. And Toba, we'd love for you to take a moment and say hello.
Hi, everyone. Thank you so much for joining us. I'm so excited to get into this important topic today.
Now, we also have with us Dakari Chapman. Dakari is our Constituting America student ambassador, is 17 years old, and is currently a junior full-time college student in South Carolina. He's won Constituting America's We the Future contest twice, once for PSA, where he reminded viewers the Constitution is an American thing, so know it, and twice for his short film, Man on the Street. He's also actively involved in our National Youth Advisory Board. Dakari is also a working actor and seen most recently in HBO's The Righteous Gemstones and in Netflix Outer Banks, which just came out 3 months ago. Now, Dakari wishes to be an actor, but also a politician, but says you must be an actor to be a politician. Dakari, would you like to say hello?
Hello, everyone. Thank you so much for being here. We're so glad that you've joined us, and we hope that you enjoy.
Now, I'd also like to introduce Jeanette Kraynak, our operations director. Jeanette is a retired teacher and former PTA president, and as I said, is our director of operations. Jeanette organizes all of our school presentations and much, much more. Jeanette does a fabulous job. Jeanette, would you like to say hello?
Thank you, Cathy, for your kind words. Yes, I'd like to say hello, and I'd like to reach out to everyone. Hearing more and more every day that it looks like a lot of schools are going to be online. So that means if you're a student, parent, teacher, anyone who's watching, you know someone that's going to be taking online classes, and let's get their school scheduled for their constitutional presentation. Constitution Day is September 17th, and our calendar will be filling up.
And now for our very special guest, Professor Will Morrisey. Professor Morrisey is Professor Emeritus of Politics at Hillsdale College, where he held the William and Patricia Lamoth Chair in the U.S. Constitution. He has a new book coming out this summer Herman Melville's Ship of State, so be sure and watch for that. Now, we are blessed to have had Professor Morrisey's help over the many years with Constituting America. Professor Morrisey's helped us design many of our 90-day studies, which you can go right on our website and click on a drop-down menu, 90-day study, and peruse them all. Professor Morrisey has written over 36 essays for our studies over the years. Many of them are prestigious opening and closing essays. And also, Professor Morrisey was actually on one of our winter mentor trips when we brought our contest winners to Washington, D.C. He joined them and was part of our Dine with a Constitutional Scholar program. So Professor Morrisey is intimately familiar with Constituting America, and we are just so excited to have him. Now, I want to mention Professor Morrisey's other books. They include Self-Government, The American Theme, Presidents of the Founding and Civil War, and then The Dilemma of Progressivism, How Roosevelt, Taft, and Wilson Reshaped the American Regime of Self-Government. And he also has a book, Churchill and de Gaulle, The Geopolitics of Liberty. But today, Professor Morrisey is going to be talking about Federalist Paper 78, and we are going to turn it over to him and ask you, Professor Morrisey, if you'd like to make some opening comments.
All right. Yes, I would. Thank you. The first thing you have to think about when you're thinking about any act of statesmanship, like the Constitution, is that a statesman or a politician isn't thinking quite the same way as a philosopher or a theologian would think. A philosopher or a theologian is going after trying to discover general truths, whether it be a scientific one like E=mc², or the laws of gravitation, or anything like that. All men are created equal would be a theoretical truth. A statesman is looking for a different kind of wisdom or a different kind of knowledge. He's looking for practical knowledge. The old-fashioned word for that is prudence, practical wisdom. And so when you're thinking about the Federalist 78, the first thing you have to think about whenever you're thinking about a political man or a political woman is that what's the circumstance? What's the actual circumstance they're working in? What are they working against? Now, in the case of the Federalists, of course, they're working against the Articles of Confederation. So the first thing to talk about really is to talk about what the judiciary looked like under the Articles of Confederation. Now, as you know, the Articles of Confederation government, the federal government under that system, was basically just a legislature. And it was a unicameral legislature. It wasn't a bicameral legislature with a House of Representatives and a Senate. It was just one body that met together. As far as the executive powers were concerned, it had some executive powers folded into it, but most executive powers belonged to the states. The federal government laws depended upon the states for their execution. In terms of the judiciary, there was only really one type of crime that was strictly a federal issue in the sense that there was a separate federal court to deal with it. And that was crimes on the high seas, piracy, that kind of thing. Now, there was nothing internal. If you were guilty of treason or you were accused of treason, let's say I was accused of treason in New Jersey, which is my home state, I would be tried by a jury in New Jersey, which means that I would have a very sympathetic jury if I could very easily get off on a charge like that. The main type of dispute, the main type of legal dispute that the Articles people were worried about were boundary disputes between the states. There had already been a number of militia skirmishes, violence between the states during that period, and the Articles attempted to deal with that legally with this very complex system of appointing what they hoped would be neutral but temporary courts to deal with these issues. If you look at Article 9 of the Articles of Confederation, we don't need to go into it now, but it's a very complicated system. And it has nothing to do directly with an established federal court. And finally, there would be disputes over the interpretation of the articles itself, the kind of thing that we would deal with the Supreme Court. And it says in the articles, every state shall abide by the determinations of the United States in Congress assembled, and all questions which by this confederation are submitted to them. So in other words, the Congress does control that, but it's a judicial function that's been folded into the Congress, into the legislative branch. It's not separated out. So what you're looking at under the Articles regime is primarily a kind of league, a confederation of mostly sovereign states. It's supposed to be a perpetual union, but if you don't have any federal court system, as Hamilton will point out later on, how are you going to keep that perpetual union perpetual? How are you going to perpetuate it? Now, the defects of the Articles of Confederation, according to Hamilton, he mentions these just very briefly at the beginning of Federalist 78. And there he said, and what he's alluding to is he's alluding back to Federalist number 22. He has three objections there to the judiciary as understood in the Articles. For one thing, there's no sanction for violating the federal government's laws. He says, this gives us, quote, the extraordinary spectacle of a government destitute even of the shadow of constitutional power to enforce the execution of its own laws. So that's a major problem, right? The second thing, he says that there is a lack of a judicial power because laws are a dead letter without courts to expound and define their true meaning and operation. You can have all the laws you want, but they are as dead as the laws of Hammurabi if you don't have a court that applies them to a living court, living judges who apply them to living people in real life cases. See? So in that sense, the laws should be alive, right? In that sense. We'll get back to whether the notion of a living constitution is quite what Hamilton has in mind. But for the moment, it should be alive in that sense, for sure. And then finally, the third thing is, he says there's a need for uniformity. You need a uniform rule of civil justice with regard to the federal government. You can't have all these different courts, many of them controlled by the states, just saying what the law is. A treaty, for example, under the Articles of Confederation could be litigated in any of the states. It couldn't, there was no way, a treaty, that's a treaty with a foreign power, right? Didn't make any sense. So those were his criticisms, those were the defects of the existing articles. Now, at this point, we haven't dug into Article 71, Federalist 78 yet. So are there any questions though, or comments about this circumstance? This is the concrete circumstances that these statesmen had to deal with. This is the limitation of what they're the practical problem that we're being faced with.
Well, I just want to say that was fascinating because I have to admit, I've mentioned before as a political science major at Texas A&M University, I never read the Federalist Papers. And I don't recall, studied the Articles of Confederation. And when I learned from you that the Judicial Branch was actually in the Legislative Branch and the Articles of Confederation, I just thought, wow, that is something I didn't know, and makes a lot of sense that they would want to split it out. But I want to go to Tova because I think Tova may have a question before we go much further. But thank you so much for that overview. That was fascinating. Tova?
Yes, so I was wondering if there's any, is this a unique system that Hamilton devised, or was that a system that had been present in other countries that Hamilton could have drawn his knowledge from when considering the context of this paper?
Publius, the three authors of Publius, Jay, Hamilton, and Madison, and most of the founders generally had read Montesquieu. The Spirit of the Laws, a book that was published around, I think it was around 1714, a couple of generations before they came along, in other words. And that was their almost a textbook for designing a Republican regime that was viable. Rather, the problem, as you know from Federalist 10, right, was that the ancient republics were very small. They were in city-states, right, and so they couldn't defend themselves. They were highly factionalized. What Montesquieu is saying was that, well, as a matter of fact, there are ways of getting a republic that's big enough to defend itself in a dangerous world, and at the same time, without making it despotic, without losing the republican character of the regime. And that was by the device of what? Representation. You're very familiar with that from previous Federalist Papers. Does that answer the question? Good. Now, anything else, or do you want me to dive right into 78?
Dakari,
Okay.
did you have a question before he dives in?
Yeah, my question was, why do you think that Hamilton was so careful to point out the importance of the judiciary?
Well, of course, Hamilton was a lawyer, for one thing, and many of the founders were lawyers. That's why they were, to some extent, why they were able to frame a constitution, a body of authoritative laws. You need people who have that experience. And so he was well aware of the need for a good judicial system in order to practice law. If you're going to have a regime that obeys the rule of law, and you don't have a decent judiciary system, where are you? Up a creek without a paddle is where you are. So that's why he's thinking this way. Yeah. Is that responsive to it? Yeah, okay.
Yeah, great question. Well, do you want to go on with your overview and your outline a little bit? And then I think this is a great way to do it. Talk a little bit more and then pause, and we'll do some more questions. And I also want to ask the audience, we've got some great minds in the audience today, and please type your questions in the Q&A queue, and we'll try to get to some of those as well.
Yeah, okay. Well, in 78, the way he sets it up is that he wants to make 3 points about the judiciary. The first being the mode of appointing federal judges. Second of all, the tenure of their office. And finally, the overall judicial system. How does the federal judiciary relate to the state court system, et cetera? That third one, the judicial system, is addressed in number 81, and I believe you'll be talking about that next week. And the first one, the mode of appointing federal judges, he doesn't really spend much time on that, because he says, look, that's already been dealt with. It's the same. You get to be a federal judge the same way you get to be the Secretary of State or any of the other major offices in the government, which is that you're nominated by someone, and in the case of a Secretary of State, the executive branch, and then, or in the case of a Supreme Court judge, by the executive branch, and then you're confirmed by one of the branches of the legislature. So he says we've already dealt with that. I'm not going to talk about that now. This one, 78, is really talking about the tenure of offices. And he says that basically what you do, you hold your office as a federal judge during good behavior, meaning if you don't commit any crimes, you don't take any bribes, you're set until you no longer either are willing or able to serve as a judge. And he says that this is a modern improvement on judicial system, and it works equally well no matter what the regime is. It's good in monarchies, and it's also good in republics. So it's regime neutral in that sense. Well, why is this a modern improvement is the question. Well, he has 6 points that he makes about that. First of all, the judiciary is the least dangerous branch. It's not dangerous, is the first point he wants to make. And it's least dangerous in a certain way. It's least dangerous with respect to the political rights under the Constitution, political rights. What is he addressing there? Well, he has to persuade the states that this more centralized form of government under the judiciary and under the other 2 branches is not going to endanger them. And his argument goes like this. The judiciary is the least dangerous branch to your political rights because the judiciary, first of all, does not wield the sword. It can't force you to do anything. Second, it doesn't have the power of the purse the way the legislature does. It can't induce you to do anything by holding back money, right? And it's dependent upon the executive branch for its enforcement. So it's entirely dependent. This is the famous line when the John Marshall Supreme Court made a ruling about the Cherokee Indian Nation. Andrew Jackson, who didn't like it, said, well, supposedly said, Justice Marshall has made his decision, now let him enforce it, knowing that he can't. Right, so it's not for, it has no force, it has no power of coercion, and it has no, what he says, it has no will, meaning it doesn't have the power to over your will. It cannot induce you by paying you money. So that's the first point. It's the least dangerous branch in that sense to your political powers. It's also not, that's a kind of negative thing, right? It's not dangerous. That's a good thing because it lacks something. It's good also because it's not the traditional type of way of dealing with cases. If you think about a monarchy, you talk about the king's court or the queen's court. Well, traditional monarchies were judiciaries. They were the supreme, the king was the supreme judge. He was, that's why it's called a court. We keep the name, but the thing is gone, but the original name had a real meaning. And he says the judiciary, the federal judiciary, will always be the least dangerous branch unless the judiciary becomes indistinct. It's melded with either the executive or the legislative branches. Political liberty depends on separation of powers because in a limited government, legislators may not do anything they want to do, right? For example, in the Constitution explicitly says you can't have ex post facto laws. What's an ex post facto law? Well, let's say I'm the legislature and I want to punish you for something you've done, but it's legal what you've done. Well, I can pass a law and say that is illegal, and then I can say it's also illegal retroactively. I made it illegal when you did it, and you thought it was legal because it was. So this is not playing fair. So, but people would do this, and it limits the power. It gives teeth to the limitations on the power of the legislature that are in the Constitution. Only an independent court can call out the legislature if it tries to do something like that. And Hamilton describes this as an intermediary, right, between the intermediary body. The court is an intermediary body between the legislature and the people. And it says what the law is. It interprets the law. And so that's the second point. Before I go on, are there any questions? Those are two fairly complicated points that he's just brought in. Maybe we should pause here and do a question and answer.
Well, we have an audience question from Professor Klinger that I think works in real well here, because it does seem like that Hamilton spends a decent amount of time making the case to kind of to address possibly people's fears that the judicial branch might be too powerful. Hamilton is making the case as to why it won't be so powerful. And were there other national judiciaries and countries at that time that had a federal judiciary system that maybe people had thought had gotten too powerful? Did people have a frame of reference with judiciaries that had been out of control or too powerful?
Well, yeah, in the sense that, don't forget the point I made earlier, the king was the court. So if he's judge, jury, and executioner, right, literally judge, jury, and executioner, that is, and the colonists were of course well aware of King George. And in the Declaration of Independence, they talk about all the different things he's been doing because he does have such substantial powers, all brought into himself. Jefferson's definition of tyranny was the amalgamation of all three powers in one body, whether it be the one, the few, or the many.
Such a great case for the three branches. Jeanette, do you have a question?
No, I think I'm going to have you go a little deeper. I just find one of the things I always wondered is, Hamilton always said that, they were the weakest form of government. And of course, now we have a whole, the whole country stands with bated breath when the Supreme Court goes into session. At what point in history did that change, or is that something you're going to be addressing in the future?
Yeah, that's an important thing. That has to do with progressivism and the way they started to deal with the whole federal government, not just the Supreme Court, in an entirely different way.
Mm-hmm.
I will talk about that if we have time as a bit later. But that is.
Thought I might have been a little too early on that one.
Crucial question.
Professor Klinger has a follow-up. He said he was asking specifically about federal systems like Switzerland, for example. Do you know anything about that at that time?
Switzerland had a republic that was really, in large measure, it was called a republic. It was mostly an aristocracy. And I don't know what their judicial system was like, whether they separated out those things. The place to find that out would be to consult Montesquieu. He would have all sorts of examples of different branches of government, and which ones in history would have been approved by Montesquieu and which ones were not approved by Montesquieu. But no, I'm not a sufficiently knowledgeable comparative political scientist, as we say in the trade, to know the status of these different national or federal judiciaries in, for example, Switzerland.
Well, that's a great source, though, to go to.
Yeah, Montesquieu is the place to look for.
Tova?
Yeah, well, I guess I could let you get deeper, but one question that has been I've been wondering about is why didn't they want the judicial branch to be elected? Why did they want it to be appointed by the president if their concern was the King of England, the executive branch being the judge, jury, and executioner? It seems a little bit inconsistent that Hamilton would then be like, well, okay, let's have the president appoint it. What was his reasoning on that?
That's the sixth point. I've gotten through the first two. The sixth point, which we will get to in a moment, but basically it's a matter of if you're going to be a judge, you're going to need some very substantial qualifications beyond the qualifications of a legislator or even of a president. You're going to need to know the law backwards and forwards, and you don't want somebody who's just a crowd pleaser who can get votes to be on the Supreme Court. Now, it is still a Republican branch, right? Because as he defines republic in earlier Federalist Papers, a republic is a representative government, and the representatives are either elected directly by the people or they are appointed by people who are elected directly by the people. So under the original Constitution, the president is not elected directly by the people, and in fact they still go through the Electoral College, don't they? Which turns out to be pretty important, as we've seen in a couple of recent elections. See, but in those days the Electoral College was a deliberative body. You didn't go into the vote committed to a candidate in advance. You went in to you were trusted by your state to be an elector, and then you would discuss the candidates for presidency in the Electoral College and vote for him. That was the way it was envisioned. That's still Republican, but it's indirectly, it's not as democratic. See, it's a democratic republic in the sense that it's popularly based, but it's not a democratic republic in the sense that everything is a direct democracy. That, by the way, will be another thing that the progressives want to address and change.
Great question. Dakari, do you have a question?
I don't have anything right now. I'm still listening. but it is most definitely very interesting.
Okay, let me go to point number 3. That business of the of interpretation, of saying what the law is established as a really crucial distinction that Jeanine Turner actually brought up the last time I was here, and that's the distinction between the fundamental law of the land, constitutional law, and acts of Congress or statutory law, right? And here's the difference. The people are the sovereigns. The people of the United States are the true rulers of the United States. The only kind of law that has been ratified by the people of the United States is the Constitution, right? We the people, it begins, we the people. No other law starts out we the people, because statutory laws are, of course, enacted by Congress and signed on to by the president, elected representatives. So therefore, Hamilton says this: what if you have 2 statutes that have been passed by Congress and they contradict each other? Well, under statutory law, it's the last one that was passed, the last one that was enacted, that is the authoritative one. It supersedes the previous one. But when a statute conflicts with a constitution, there's no law of supersession. It's the Constitution, the original law that was done by the sovereign people in their capacity as the true rulers of the regime. They were the ones who passed that law. And if the statutory law contradicts the Constitution, it's void. See that? So in other words, statutory law could be, in a sense, progressive, right? You could refine the statutory law, you could change it with changing circumstances. But in order to change the Constitution properly, you need to do an amendment which is ratified by whom? Well, we the people, state by state. See that? So that's his third point, very important point. The Constitution affirms popular sovereignty. And it's above statutory law. It's not beyond it. It's not in the future. It's now, and it always rules over that statutory law. And you need federal Supreme Court, right, to say what that law is. Now, the fourth point is that judicial independence also guards against the corruption, not just of the government, that is to say, not just the legislature or the president encroaching on and aggrandizing itself. It also prevents corruption of the sovereign people. This is a very interesting point that he makes. He says there can be serious oppressions of the minor party, meaning a minority group of any kind, religious, whatever, the minor party in the community by a majority. The majority may, for a moment, have a tyrannical inclination, right? The will of the sovereign people may, for a moment, be impassioned against some group or other. They want to protect against that happening, right? The will of the people must be, in order to change the Constitution, the will of the people has to be very carefully and slowly ascertained by that ratification process. Now, the courts must have the wherewithal to resist these temporary passions of the people. What basically is the Constitution trying to do? What kind of regime are they trying to do? They're trying to do a popular government, but it's a popular government by consent. Consent doesn't just mean assent. Consent just doesn't mean I'm going with the passion of the moment. Consent means rational assent. It means that you've thought it over, you've considered it, you've deliberated, you've resisted the passion of the moment. The courts slow people down. Constitutional courts slow people down so that if they try to do something that is against the Constitution, they won't be able to do it until they've actually thought about it for a while and amended the Constitution. A good example of that would be one that did get into the Constitution was prohibition, right? In the passion of the moment, anti-alcohol folks who had a reasonable argument in a sense, right? They wanted to prevent drunkenness and so forth. They got a constitutional amendment, but then they thought it over and they revised it. They got rid of that constitutional amendment. It makes consent. It makes for government, popular government, reasonable and moderate, true consent. And that's consistent with the Declaration of Independence, isn't it? Because the Declaration of Independence says it's the consent of the governed that will secure your inalienable rights, not mere assent, not mere popular passion. Well, that won't do it, because your unalienable rights are easily destroyed by an impassioned majority that has power on its side. Very dangerous. So that's the third and fourth ones. I'll pause again before going to number 5 and 6. Those are crucial points, right? So any comments or questions on that?
This is a lot. This is great. I'm learning so much, and I'm just sitting here taking notes. Tova, do you have a question?
Not that I can think of at the moment, but this is really interesting. I'm like taking so many pages of notes. I'm learning so much. So thank you.
Okay, and so I'll go to the 5th and 6th point then. Hearing no objections, I'll go to the 5th point.
And I'll just say, Professor Morrisey, before you go to 5 and 6, we do have a few questions.
Oh, good.
That have been emailed in, but they are more on modern day. So okay. I was going to wait till you get through the points of sort of summarizing the paper, and then maybe we could talk a little bit about modern day too, and how things have turned out versus how they were set out.
We'll see how well I do on modern day. I'm a man who lives mostly in the past. As befits my great age. All right, now, the 5th point, and this is related to government by consent, reasonable and moderate government, right? One of the things you need, and this actually speaks to a major issue that's current today. One of the major things you need, especially in Republican government, but really in any form of government, is trust. If you can't trust your fellow citizens, if you can't trust the people who are ruling you especially, then otherwise, he says, if you don't have trust, no man can be sure that he may not be tomorrow the victim of a spirit of injustice by which he may be the gainer today. In other words, as a transient majority, a passionate transient majority, as a member of that majority, I may get a big advantage over you today, but what about tomorrow? Maybe I'll be in the minority tomorrow. How can I trust a government that's always wavering, always ruled by these whimsical majorities, right? These majorities that will do one thing today and another thing tomorrow. One of the basic things in any civil society is the ability to trust your neighbor. If you can't trust your neighbor, at least on some basic level, you're not going to have a civil society. You're going to have an uncivil society, which is a state of war. And you're going to get a civil war. You're going to get extreme factionalism. People are going to start taking up guns against each other and shooting at each other. And you can see a little bit of that right today. When people stop trusting each other, they start shooting at each other. And then finally, and Tova jumped the gun on this one, right? The qualified judges, he said, and he makes the point, few men in the society will have sufficient skill in the laws to qualify them for the stations of judges. And that's just a practical point. You need to know, if you're going to be a Supreme Court judge, you really do need to know not only the Constitution, but a body of legal decisions, and you need to know something about the state laws. You need to have a kind of disposition, right? A certain kind. Not everybody is fit to be a judge. I'm not so sure I'd be such a great judge, right? I might not have a judicial temperament. Some people don't. A lot of people don't. But you need people who are qualified for that job, and that's why you need this new system of a Supreme Court, a federal Supreme Court. And that is my overview.
That was a great overview. And now we have a question from one of our previous contest winners, Haley Moke. And I think what you just told us, we could probably put some of these pieces together and answer Haley's question. Haley writes, I believe in limited government. It seems like judiciary has so much power today, which is not what Hamilton envisioned. Where do you think the present rise of activism in the courts will take the country? Is Congress shirking their responsibility? And I might add, how have the courts become so active? I mean, Hamilton obviously didn't envision that. He envisioned it to be a weak branch, but how have they gotten so powerful?
Well, I give you the political thought of Woodrow Wilson. Woodrow Wilson was a college professor at Johns Hopkins in the 1880s. Well, he was a student. He was a graduate student there in the 1870s, and then he became a professor, eventually became president of Princeton University, then governor of New Jersey very briefly, and then finally president of the United States. His theory of the Constitution was against the basic theory of the founders. And he was against it on from the deepest level down. First of all, the founders, of course, as we know, derived all political and civil rights from natural or unalienable or God-given rights, which are permanent. And so as long as human beings exist, they have these inherent, inborn rights to life, liberty, the pursuit of happiness. Wilson says, no, rights do not derive from nature or from nature's God. What rights derive from is history. And I don't know if I've talked about this before on the distinction between a natural rights idea and a history-based idea of rights. Have I done that before here? If not, I'll be happy to explain it. This is a crucial point with Wilson and the progressives, and it's a sharp break. It's preliminary to answering the actual question about the judiciary.
Yes, please explain it.
Okay. Let's say the founders derived right from natural, the laws of nature and of nature's God, which are permanent until God changes them, right? And in the late 18th century, David Hume, who was a Scottish philosopher, attacked natural right as the basis of right. He said it's just a myth. And he says, nature is nothing but matter in motion. It's just a bunch of molecules vibrating meaninglessly. You can't possibly derive right from that, right? And how can he says, you can't derive ought from is, right? Philosophers call that the is-ought problem. You can't derive anything from that. Furthermore, as an Enlightenment secularist type, Hume also rejected God as the origin of right. So if you eliminate God and you eliminate nature as the source of right, where do you get right from? Where does it come from? In Hume, it just comes from human conventions. We agree to these things, and we've had long traditions, and they're just kind of arbitrary, and they vary from country to country. Enough said, that's the end of it. In Germany, in the early 19th century, there was a school of thought which we now call historicist. The famous member of that, the leader of that school of thought was a man named G.W.F. Hegel. Hegel says, here's how right comes about. Human beings, over the course of time, have gradually taken this meaningless matter and motion type of nature, and they've conquered it. They've shaped it to their purposes, and they've done so progressively over time. We've gotten better and better at doing this over the centuries. And as a result, what right derives from is what he calls the absolute spirit. The absolute spirit isn't God. The absolute spirit is innate in everything. And it's gradually evolving and unfolding. And this human conquest of nature is part of the unfolding of the absolute spirit. Now, do you get that so far? That's kind of complicated, but you see the distinction, at least, between natural right or God-given right and this thing called the absolute spirit, which is not a creator God. It's an it, not a person, right? And it's unfolding over time. Everything is evolving. Okay, if that's the case, then governments and constitutions should be easily evolving too. The original metaphor that Wilson used is that we should have an elastic constitution. That is to say, it should stretch, and judges, but also presidents and legislators should treat the Constitution as if it's growing with the spirit of the times, as the absolute spirit unfolds, right? In your lifetime, you change the laws without, the Constitution was old, it was retrograde, it was under the laws of Newton's physics. Well, we now have Darwin's evolution. Isn't that so much better? See, so it's the elastic constitution. Then he came up with a better metaphor. He said, we're going to call this the living constitution, meaning it's always growing like a living organism. It's always changing, and that's good. See how that changes Hamilton's view and the founders' view. The founders are saying the Constitution is up here and statutory law is down here, and the statutory law has to match constitutional law, just the way constitutional law needs to match the laws of nature's God, which is higher than it is. See that? It's a hierarchy. With this, the authoritative thing is not in up above, it's in the future. It's the future that is authoritative. And you as a judge, you as a president, you are the cutting edge of history. You've been elected to be the leader of history. Well, that means what? That means that laws don't really constitute anything much anymore, do they? If the laws are ever changing, then they have no backbone. They have no, this organism is like an amoeba, it just grows and multiplies. And see what I'm saying? So that's the distinction, and it's a fundamental philosophic distinction that then plays out into this constitutional and judicial distinction. I'm hoping that answers the question that the individual asked.
So basically you're saying that the rise of judicial activism started in the administration of Woodrow Wilson.
Well, the theory of it starts in his political thought and that of judges who were appointed who were known to be progressive.
At that time.
Oliver Wendell Holmes, right, and a variety of others, yeah.
Okay, no, I think that's a great answer. Tova, do you have a question?
Sure. So was there any opposition to this kind of philosophy of Hamilton or his plans for the judiciary? Was there substantial opposition to this when he introduced it, or did people generally agree with it as the basis for a government?
Well, the anti-federalists, of course, were very powerful in a number of states, and they didn't want anything to do with this or any of the other parts of the Constitution. Now, some of them were basically not so much worried about the institutional features of the Constitution as the fact that it lacked a Bill of Rights. And of course, Madison, who's one of the Publii, right? He fixes that when he's in charge of he's putting the Bill of Rights into the Constitution. He's making these amendments and formulating these amendments and getting them out for ratification while he's in Congress. So he doesn't mind that either. So a lot of the anti-federalist opposition melted away after that, but there were still the hardcore anti-federalists, to be sure, who didn't like it. And in fact, when the Confederates, when John C. Calhoun is trying to defend slavery and empower the southern states to defend slavery, what does he do? He tries to kind of reformulate a new way in which the states can be made impervious to federal legislation with his concurrent majority thesis, something that you can read about on other Constituting America documents. Anything, is that it?
Do you have a follow-up, Toba, or?
Are you satisfied?
I am, thank you.
Okay.
I don't. It's very, when you read the Federalist paper, I'm very convinced. So
Yeah.
I can
Well,
see how people
you can find, by the way, if you want to, it's good to read the Anti-Federalists, and there are collections of Anti-Federalist essays, so you can compare and contrast. The most famous and the most able of the Anti-Federalists wrote under the name of Brutus. They all like those Roman pseudonyms, and he was from New York. I forget who he was in real life, but he's the best of them. If you want to get the strongest anti-federalist argument, he's probably the one to consult.
And I think we'd like to do some future chats maybe on some of the anti-federalists. It might
Sure.
be interesting.
Yeah.
Dakari, do you have a question?
I do not have a question, but I do have a comment, and that is that this has been absolutely the most fascinating thing ever. And I've learned so much, and it's always good. I always tell someone, when I can walk into a room of a professor or a Zoom chat of a professor and I have no questions, they have definitely done their job.
Well, thank you.
Well, and Jeanette, you had wanted to, did you have a question, or you'd want to save your question, or?
No, I think he covered it with Wilson. A lot of things in history lead back to Wilson, but that's a horse of a different color for another day. But yeah, we did this. You did address my question as to when this turned, when the popularity of the Supreme Court. I mean, the importance of it, like I had mentioned earlier. You know, I think Hamilton would be shocked that, you know, every year this country stops in the beginning of October to see what will they do. I mean, it's the Supreme Court has become just a huge part of the government, which they never thought it would be. And I think my question was, which he addressed, when did that turn?
Yeah, it's not just Wilson. Wilson is one of the preeminent ones, but there's a whole movement. And if you ask, and it's an interesting question, who are the voters for the progressives? Because of course Wilson won the presidency in 1912, and even Theodore Roosevelt was running as a progressive on something called the Progressive Party, right? So who are these folks? The core of the progressives were the newly formed, much more powerful professional classes. Not just lawyers, but doctors, and especially school teachers who saw themselves as the cutting edge of history, who would then educate the students and bring them up to what they wanted them to be. See that? And so that was the core constituency of progressivism in those days, and that's why they got votes. These are people who do vote, right? Professional class people vote. If you expand the federal government, that's going to be more work for lawyers. That sounds good to a lawyer, right? Any type of professional class person who believes that he's on the cutting edge of this thing called history is that. Oh, by the way, there's another little note that I like to make to students. Why does the Declaration start out with the phrase, "when in the course of human events," instead of "when in the course of history" or "when in history"? And the answer is that to the founders, the course of events doesn't mean history. The history to the founders means a genre of writing, an inquiry into the course of events. It's only when Hegel starts talking about history as this unfolding, the story of human progress, that's when history and the course of events become one and the same thing.
Well, that is fascinating. I'd never heard that before. And that,
I used to ask that. I used to ask that of all my Constitution classes. The first thing we do is the Declaration. I'd always ask them that question: why not when in history? Nobody ever knew. Nobody ever knew.
And that may be a great way to wrap up today with the Declaration of Independence. Professor Morrisey, we just thank you so much for being on today and walking us through Federalist 78. And we thank everyone in our audience for their questions and their participation. And we especially want to thank our sponsor, Jane and Greg Gandy, who made this possible today. We're very grateful for the Gandys sponsoring our chat. If you'd like to sponsor a constitutional chat, you can go on our website under Learn More. There should be a button, sponsor a constitutional chat, or email me at Cathy, C-A-T-H-Y, @constitutingamerica.org.